Okay, let's continue on and talk about how the Australian consumer law might apply. Now, if this is unfamiliar territory for you, whether you're a law student or a business student or IT student, I strongly recommend that you go and have a look at the recommended text because it has some fairly useful, very useful overview of what the Australian consumer law is, how it works, and when it's relevant. And I'm not planning to do too deep a dive here. So basically the key reading here is the Mackey article, and I strongly recommend that you have a good look at that. And basically Mackey points out the ways in which the Australian consumer law might be a better approach than tort law when we're considering the liability of manufacturers, distributors, vendors of autonomous vehicles. So particularly if a connected autonomous vehicle, that's the language he uses, CAVs, connected autonomous vehicles, if there's an allegation that a CAV hasn't performed in a manner that's been advertised or expected by its owner or user, or if they have a safety defect, then a claim for damages under the Australian consumer law might be considered in addition to or instead of redress under other legal remedies like torts or negligence specifically is what we've been talking about. There's a variety of claims under the ACL that could be possible. So for personal injury, loss or damage to other goods, to loss or damage to buildings, to fixtures or land. And the threshold requirements for these claims may well be less demanding than the claims that are brought in negligence, where the level of proof and the onus of proof is quite high. And in many cases, the legislation provides strict liability claims. So if there is that causal link, if the act or omission results in damage, it doesn't matter whether or not you intended it. It doesn't matter whether it was foreseeable or not. It's a strict liability claim. So claims can be brought in relation to goods or services. They can be brought against manufacturers or suppliers. The definition of a manufacturer is expansive and it can include a number of entities in the supply chain. The ACL also provides for various statutory guarantees in consumer transactions and for consumer goods. So again, it's important that you look at what the definition of a consumer transaction or consumer good is, but generally speaking, we're talking about goods or services that have a value of $30,000 or under, or which are ordinarily used or expected to be used for household or domestic purposes. It's a little bit more complex than that, but I'm warning you, look at the definition if you need to, but just be aware, the real learning point here is you need to be aware that the definitions will be important. Another really important part of the Australian consumer law is it provides for various statutory guarantees in these consumer transactions, and it prohibits unfair practices, including false or misleading representations. So when statements are made about the safety or about the capabilities of an autonomous system, that could be particularly relevant. The guarantees include that goods will be of an acceptable quality, that they'll be fit for purpose, that they'll be safe, and that they'll be free from defects. The ACL is a really good way of thinking about this because it could bring in action under the ACL if you've suffered harm because of an autonomous system. It could potentially avoid many of those threshold complications regarding who the driver is, for example, and it might more easily allow actions against manufacturers under compulsory third-party and national insurance schemes and avoid the hurdles of identifying who's at fault that are present in general recovery through negligence. However, there are some major concerns that arise if the ACL is going to be viewed as a solution to the problem of liability for automated vehicles in particular, and Mackey goes through them in some detail in the article. So he points out that in Part 3.5 of the ACL, if an automated vehicle manufacturer supplies a vehicle with a safety defect and that defect causes loss, then Part 3.5 of the Australian Consumer Law is likely to apply. And the relevant test here for determining whether something is defective or not is effectively a consumer expectations test, very similar to one that's been developed and applied in the US over the last few years. So manufacturers may be held liable under this defective test if the goods that are supplied, if the safety of those goods is not such as persons are generally entitled to expect. So what would a reasonable user expect? So this helps us as we're thinking about if you're in business, if you're advising or you're working in as a manufacturer in the design or the development or in providing marketing even, you've got to think about what the potential defects will be and what kind of redress might be available and what is reasonable for you to do in order to avoid that, or if it's a strict liability offence, to ensure that it doesn't happen effectively. So how might this play out in the real world? Again, my little poem in the third video was trying to provide you with inspiration as much as anything else of where these issues might apply. But let's focus ourselves on a self-driving car, for example, and it gets into an accident due to a software glitch. The manufacturer could be held responsible for the software issue, while the car owner could be held partially responsible if they failed to perform regular software updates. So that's your contributory negligence element. So under current Australian law, claims against automotive vehicle manufacturers and their subcontractors are likely to be primarily handled through the various theories of liability available in Australia's product liability regime, the Australian Consumer Law, and, of course, the tort of negligence. So, again, each time we've got to think about, well, what laws are available and which is going to provide the most effective and efficient redress when a plaintiff brings a claim. And there are plenty of different examples that we could use. So healthcare robots, for example, if they cause harm to patients due to incorrect data that's input by a nurse, who's responsible? A hospital might be held liable for the nurse's negligence, but the patient could also have a contributory impact if they failed to disclose relevant medical information that impacted the robot's decision making. Before deploying AI systems, businesses need to consider the various legal issues that could arise during the operation of the technology. So this, one of the key areas that we keep coming back to is that allocation of responsibility between the different parties involved in the development, deployment, and operation of the AI. We can address this through contracts and insurance policies as a starting place. So before deploying an AI system, a business is going to need to consider the various legal issues that could arise during the operation of the technology. And one key area is the allocation of responsibility between the different parties involved in the development, deployment, and operation of the AI. So why do I say contracts are useful for that? Because contracts are literally about allocating risks. When a contract is drafted, effectively people are making decisions about what risks will they take on and be responsible for, and what effectively will they pay somebody else to be responsible for. So often the less money that you receive for delivering something, the more risk that the party paying is taking on, and vice versa. Now that's a very rough and ready analysis of the way negotiations work. But if we think about contracts as a vehicle for allocating risk, I think that that's a really useful way for thinking about how businesses and lawyers need to think about the legal considerations well before something goes wrong. Similarly, insurance contracts are about risk. They're about insuring for risk. Now, clearly, the higher the risk, the higher the premium, or maybe the impossibility of getting the premium. In the context of artificial intelligence and autonomous systems, parties can proactively address legal liability considerations by using contracts, insurance, or a combination of the two. When it comes to contracts, parties involved in the development, deployment, or use of AI systems can establish contractual agreements that outline liability allocation and risk sharing. These agreements can define the responsibilities of each of the party, including the developers, the manufacturers, the end users, the distributors, etc. And they can set out who's going to do what in the event that damage or harm is caused by the AI system. Of course, a contractual agreement is never going to cover all the potential issues or all the potential things that can go wrong, and third-party claims could still arise. A contract might not, for example, protect a party from claims brought by a consumer who suffers harm as the result of the actions that weren't foreseen but fall under that strict liability offence or under relevant legislation. Similarly, where the legislation has strict liability, it may well prohibit contracting out of that obligation. So a contract that says, we don't know what our AI is going to do, but it could do harmful things and you do that completely at your own risk. If that's a consumer contract, it may well be that there is a strict obligation to ensure that the product is not defective and you can't contract out of it. Insurance policies can offer protection against potential liability arising from the use of AI. They can be tailored to cover various risks associated with AI deployment, for example, the damage that's caused to property or injury to individual. Now, it's always going to be essential to carefully assess the scope and the terms of the insurance policy. They're just contracts after all, and they may not have adequate cover, or they may not cover all the risks, and premiums may just be too high to be commercially viable. So when considering contracts of insurance, it's critical to understand the potential issues and the limitations for each approach. Effective risk management involves striking a balance between the contractual risk allocation, the insurance coverage, and the potential costs of both. In the context of AI and autonomous systems, a comprehensive strategy that combines well-drafted contracts and a suitable insurance policy is likely to help a party mitigate legal liability risks and ensure a smoother deployment and operation of the technology. But these are all new areas, so who knows?